Thank you for joining us. The following presentation is from a webinar titled Taxation of Trusts and the Vital Importance of Selecting the Proper Trust Situs, originally produced on November 19th, 2015. The presenters are David Warren, President and CEO at Bridgeford Trust Company, and Tyler Wanger with McKonly Asbury. Enjoy the presentation and visit us online at www.macpas.com for more information about our future events and upcoming webinars. And David, before we begin, I just want to do a quick introduction for you, because I know you probably won't do one for yourself, but some of the callers on today's call might not realize that not only are you the president and CEO of Bridgeford Trust Company, but you're also on the board of directors, and you also are one of the co-founders of Bridgeford Trust Company, the organization, which is pretty impressive if you ask me, and we're definitely excited to have you on here. But you also have 18 years of professional experiences in practicing law and working in the financial services industry, such as trust management, and wealth management for those of high and ultra high net worth families across the nation. So we're super excited to have you today, and we're eager to hear what you have to say. So go ahead and get started.
Thanks, Tyler. We're happy to be here and excited to talk about the topics that we're going to go over today. The title, of course, sort of speaks for itself. The presentation is going to focus on jurisdiction generally in terms of making the proper jurisdiction selection when you're engaged in the wealth planning process. It's a topic that we're particularly passionate about at Bridgeford because we think it really makes a huge difference and can have a huge impact on the plan. Now, there's a quote that you see that has really driven a lot of the reasons as to why we built Bridgeford the way we did, and it guides us in many ways in terms of our discussions with clients and attorneys and accountants around the country and increasingly around the world. And the choice of a state in which to establish a trust is as critical as the decision to create one in the first place. And I think that's more true now today than it ever has been, because as we're going to talk about in the next hour or so, there are particular factors that really make a tremendous impact relative to certain planning techniques that are available to planners around the country. And again, not only around the country, the U.S., but even around the world. I've recently spent over 2 weeks in Europe talking about U.S. trust law and meeting with attorneys and accountants and financial people, many of which are on this call today. So it's good to see my new friends from Europe join us, as well as friends from around the country. We have states represented from California to Florida to Massachusetts, and I appreciate you participating, and it's good to see you on the call. But this decision, again, as to where to place a trust, has just become vitally important. And I think that we'll go with that paradigm throughout the hour discussion. So it's really exciting to watch this sort of evolution. When we got started the process of launching Bridgeford, it became very clear that there's an amazing race going on right now among 4 states to be the top trust jurisdiction. And for those of you on the call that follow this, you know full well that this is a dynamic area. It's quickly changing, and I think for the practitioner, we need to stay on top of these emerging trust laws. And unequivocally, in almost all the publications, the 4 states that you see there, South Dakota, Delaware, Nevada, and Alaska, they are consistently considered what they call top-tier jurisdiction, particularly by Trust in the States magazine, but also law review articles and other publications. And we're going to talk briefly in a moment about the various factors that are looked at when this determination is made. And I'm going to hit on a couple of the topics, and then we're going to shift the conversation to more of a focus on taxation, because there are trends developing in the United States, particularly in the area of taxation of trusts and retained income in trusts, that make this jurisdiction selection even more important, because to make an incorrect trust jurisdiction selection can have actually some pretty measurable consequences relative to taxation that's levied on the trust. So I think over the last 18 months to 2 years, we've seen this develop. I'm excited about the topic and have become increasingly passionate about making sure that practitioners know that there is a difference among the states, particularly with respect to taxation, and we will certainly get there. So the factors that are generally considered when determining what is a top-tier trust jurisdiction, these are factors that folks at Trust and Estates Magazine look at, lawyers, accountants, people who are really concerned about finding the best trust jurisdiction. And in the order of how we're going to look at them quickly is asset protection, taxation, privacy rules, rule against perpetuities, which is a way of saying dynasty trust, and modern trust laws. These areas, these 6 areas, or 5 areas, they're looked at in a way that and analyzed and compared from state to state. So, for example, not every state has asset protection. Not every state does not tax. Not every state has any privacy rules and so on. But even among those states that have these components about or in their trust law, even among those states, some are better than others. And so we're going to cover that somewhat briefly and go through some of these topics, and then, as I said, transition into the taxation piece and into an area that I think is growing and emerging and becoming quite compelling. So asset protection briefly, the Domestic Asset Protection Trust has been around for many years and it continues to be a hot topic. In the United States, the Domestic Asset Protection Trust really provides an alternative to going offshore. Why that's important, and I realized how important that was as I was in Europe last month, is often, and particularly now, the international jurisdictions where you've heard in the past, like Cook Islands or Bahamas or maybe even Nevis or others, practitioners are becoming nervous about placing assets there for a myriad of reasons, some of which have to do with the stability of the government. And the United States, particularly Delaware and South Dakota, 20 years ago, came to the conclusion, well, why should money have to go offshore to enjoy some asset protection? So what's so amazing about, well, amazing is probably a strong word, what's so interesting about asset protection as it applies to the Domestic Asset Protection Trust is that it's a self-settled trust, meaning the settler still has a great deal of control and can take distributions and can take income and can enjoy some pretty compelling asset protection capability. Among the states, they're not created equally, and very briefly, the main probably point of comparison is what is called the fraudulent conveyance statute, which is really a fancy way of saying look back. And after 2 years of properly establishing the trust, 2 years later, protection vests, and in Delaware it's 4 years. And that's an important comparison, and it's the reality of when you're looking at these states, which state is better than others in certain topics. Clearly, I think South Dakota and Nevada is another one, are a little bit ahead in terms of that fraudulent look back component to it. Now, there's some debate, Tyler. We across the country, and I spent a lot of time in California and New York City with attorneys, and really across the country. And there's some question as to whether or not asset protection works. Domestic asset protection even works in the United States. And the reality is, as great as that is as an intellectual conversation, there's not a single case at this point that has had this overturned or otherwise shot down an asset protection statute. There are aspects of execution or administration that has made them weak because they weren't handled correctly or there was a fraudulent transfer, but that doesn't mean the statute themselves are bad or they don't work. It just means that you got to do it correctly. And I say that somewhat tongue-in-cheek. That's where the failure is, and that's where it's incumbent upon a trust company that's doing this work to do it correctly, because if you don't, the consequences are the asset protection will be pierced. So generally, wanted to just touch on that and remember what we're doing. This is just one aspect, one of 4 or 5 or 6 components that are looked at to determine which is the best trust jurisdiction. Another aspect is privacy. Increasingly, privacy is a very important issue for families. I realize that in Europe how important it is, which has obviously driven so much investable assets and other assets to Switzerland over the years. We all know that's changing very quickly. And Switzerland isn't quite the privacy haven or tax haven it used to be. And once you remove the privacy and secrecy component to Switzerland, we have international families who are saying, well, now what? Now what do we do? Where do we go? And what we're seeing, quite frankly, is South Dakota has become the choice for international families around the world. And it's because Well, it's for many reasons, but in this instance, it has a lot to do with its trust privacy provision. South Dakota is the only state in the country right now that has a total seal on records or litigation records that are connected to a trust. So what I mean by that is, in most states, when a trust gets involved with litigation, or there's a will contest, or there's anything about that trust that finds its way into the court system, all of that information becomes a matter of public record. It could be discovered. It can be easy to look up. You can look up beneficiaries, look up asset base. All of that becomes a matter of public record. Well, wealthy family, no family wants that information to be part of the record. And as distinguishable from Delaware, which has a similar privacy provision, there are two really, really important distinctions there. One, Delaware is judged; it's discretionary, so the judge has to agree with you that there is a reason to seal this record. And quite frankly, I understand it's not easy to get a judge to agree to that. And in Delaware, even if you get a judge to agree to it, it's only sealed for 3 years. Well, that's a very compelling comparison, whereas South Dakota, it happens as a matter of law. A judge doesn't have the ability to say yes or no. The judge basically has to seal it because that's what the statute says, and it's sealed forever. A very important distinction, and something, again, as I mentioned, that is driving a lot of activity to, around the country, but even internationally. And Tyler, it really was amazing when we were in Europe how many people that we met with, primarily lawyers and accountants, and frankly other trust companies, knew of South Dakota. And they knew of Delaware, but they knew of South Dakota. And they was really the two jurisdictions that we heard a lot of. In fact, in some cases, they knew more about South Dakota and Delaware's capability than a lot of U.S. attorneys, which is, I find, intriguing. One other final component is that South Dakota has something called a quiet trust, which essentially means that the trust does not have to be revealed to beneficiaries after they turn the age of 18. Wealthy families really like that. In most states, there's a requirement that a beneficiary, upon reaching 18, has to start to receive statements and be notified of the trust. But often wealthy families don't like the idea, frankly, of their son or daughter at college receiving a statement that indicates that they're the beneficiary of a $100 million trust. That tends to have an impact on one's desire and drive to get their education complete, I suppose. So that's another area that has been, again, one of the many factors that are evaluated by experts to determine which trust jurisdiction is the leading trust jurisdiction. Another area generally is a concept loosely, I guess, defined as modern trust laws. These are pretty exciting laws that exists in these progressive trust jurisdictions, particularly the four that we've already mentioned. I'm not going to go into specific detail now, but the idea of having a trust protector statute, having a directed trust statute, the ability to reform and decant, and let's pause on decanting for a second. Decanting is something we're going to talk about later, but is a very revolutionary concept in trust planning right now. But when you look at all of these concepts, and we're not going to, for purposes of today, we're not going to get into the details because I want to spend most of our time talking about taxation. But when you look at all of these modern trust laws that are available, again, only in a handful of states, it delivers far more control to the beneficiaries, to settlers, co-trustees than ever before. And it really has, and I use this word a lot in the context of trust, which is funny, but it has revolutionized the trust industry. And I was just with an attorney yesterday in New York City, a chair of a trust and estates group at a 500+ law firm, and we both were very passionate about the fact that these modern trust laws have changed so dramatically the context of what is an irrevocable trust. I think 20 years ago, an irrevocable trust meant something very, very different, very rigid, unchangeable, unmovable, and was something, frankly, a lot of wealthy families didn't really like because they didn't want to give up as much control. Fast forward 20 years, Tyler, and I could tell you it is an entirely different world, and it was great to be with attorneys who see that as well, who use these trust laws. But again, we're going to focus a little bit more on decanting. I'm happy to answer questions from anybody on the call if they want to get into some of these other topics. But again, the focus is really more on what's emerged here in the space relative to taxation. A word about the trust protector before we move on. The trust protector is also a pretty new concept. More and more states have that provision. The trust protector acts as a super trustee. which is to say they have a lot of power to remove the trustee, which would be a Bridgeford. They could remove Bridgeford very quickly. They can move jurisdiction very, very easily, which is something we're going to talk about in a little while, about how easy it is to move these trusts into a more progressive jurisdiction. And that's become a very common tool, but not every state has a directed trust, or rather has a trust protector statute. Pennsylvania recently put one in place, but most states, surprisingly, Tyler, don't have that trust protector statute in place. The directed trust versus a delegated trust, that is worth a little bit of time, I'm realizing, because it's kind of drive a little bit more of this conversation. The directed trust clears the way for investment managers to work with independent trust companies and bifurcates those roles. Why that's important is because some of the wealthiest families in the country and in the world really are kind of tired of the bundled approach, which is to say a Bank of New York Mellon or a PNC or Wilmington Trust or Wells Fargo. When you go there, they're going to be your investment manager and your trust company. The functions are bundled together. Why that's not a conflict, I don't know, but the functions are bundled together. And what's happened in the last 15 or 18 years is that this idea of a directed trust splits it apart. And that's what Bridgeford does, Tyler. We don't manage money. We focus specifically on the administrative pieces. There are trust companies like ours that have developed, and it really gives infinitely more control to the settlers and the beneficiaries to be able to work with the investment advisors that they want. And those factors, and as we've gone through them, whether there's a directed trust statute, whether in the context of modern trust laws, trust protectors, whether there's asset protection, whether there's privacy, whether there's a dynasty trust capability, these are all things that are considered. And so what I'd like to do before we transition into the taxation part of this conversation is do a little bit of a comparison now of these factors and get a sense for where the states really fall. So if we go to the next slide, we'll talk a little bit about that. Well, I guess we will in a moment. The idea of a dynasty trust is a very, very important development in the United States. And sometimes, Tyler, I'm surprised by how few people know about what is a dynasty trust. South Dakota was the first state in the United States to abolish this very arcane rule that came from England called the rule against perpetuities. And I know I have friends on the call that had gone to law school around the country, and I'm sure they remember, like me, just how impossible it was to understand this rule called the rule against perpetuities. And essentially what that rule says is that if a trust a trust has to terminate at some point. The fancy legal jargon I was forced to memorize, and I'm not going to repeat it now, but although I stood, something to do with a life and being and things that nobody really understood in law school. But the point is, it triggered a termination of the trust at some point in the future based on the life of a life and being. Okay, once we remove the legal mumbo-jumbo from that, what does that mean? It meant that at some point in the future, at some generational point in the future, that trust was going to be terminated, and then what happens? It means it's subjected to federal income tax. And for very wealthy families wanting to carry on their legacy over multiple generations and avoid federal income tax, which, as we all know, is pretty painful, when you cross the thresholds of the exemptions and things, that was a problem. And so South Dakota decided, well, because it's state-driven, it's very important to understand this. In fact, at the point I probably should have made earlier, and I'm sure most people on the webinar know, all of these laws we're talking about, they're all state-specific. The states have the power to make their own laws, and they have the power to set up their trust laws the way they want to, which is going to be a theme we're going to talk about towards the end of the presentation relative to some case law. But the idea of taking this trust and saying, listen, the rule against perpetuities is gone, the trust can live forever, that means clearly that trust will never be subjected to federal income tax through the estate process. And that cleared the way for the creation of a dynasty trust. Now, a lot of states across the country have changed their laws to be dynasty trust states, and we'll see in a moment. the amount of states in the United States who have gotten to the point of abolishing or modifying the rule against perpetuities. Not a lot of states have completely abolished it. Some just have made the term longer. So usually it was 21 years is what most statutes were. Sometimes they extend them to 50 or 100 years. But there are a handful of states that don't have it at all. And so what we're going to do now in a minute is go to a chart that was prepared that takes dynasty trust states, which is to say states that have a dynasty trust capability, or in other words, have abolished or modified the rule against perpetuities, and it compares them. And what it does is sets us up nicely to transition into the tax discussion, because really the dynasty trust is the first tax play that we're talking about. I mean, what we've now transitioned to is the idea of taxation of trust, and what does it matter, and how does it matter? And so what we're going to do now is compare the dynasty's trust states, and then we're going to get into a more specific conversation of the taxation of trust. Tyler, if we can go one more, I think. Here we go, and then we'll go back. This is a chart that may be a little difficult to look at, and it's put together, difficult to see. Maybe if you can make it a little, I don't know if there's any way we can make it a little bigger. It's the fourth annual Dynasty Trust Rankings chart. There's an attorney in Nevada who's extremely prolific and spends a lot of time analyzing the various trusts to determine which is the best trust jurisdiction. And we're gonna hear about him some more later on in the presentation. But he, like me, is extremely passionate about trust jurisdiction and making sure we're looking at the right jurisdictions when we're trying to plan. And what he does is he puts together a very powerful rubric here, and it's very objective, and that's why I like it so much. And he assigns values to various aspects, and what you'll see at the top there, Tyler, is really kind of a recitation of what I've already covered. Whether the state has abolished or somehow modified the rule against perpetuities, whether there's a state income tax, and that's where we're heading next. Whether there's a domestic asset protection, whether they have a trust decanting statute in place. These are all concepts that I alluded to earlier, and these are all factors, as I've said, that go into the conversation, which is to say, which is the best trust jurisdiction. He has put South Dakota as the number one dynasty trust jurisdiction when you gather together and compare all of these various components. Again, I like it because it's objective, and it's even more credible in my view because Steve Oceans is a Nevada attorney. And it would have been very easy for him to say that South Dakota was second and Nevada was first here, but he didn't. And I think this chart is very instructive, and I think it's a compelling tool for practitioners to take a closer look at. So as I said earlier, just because states have these laws or these provisions, as we've gone through at the earlier part of the presentation, doesn't mean, however, that that's all you need to worry about as a practitioner or particularly as a client. What you should be concerned about is, okay, well, how do they compare to one another? And what's so great about this chart is it really puts it all together into a nice, neat way. Can we go back to the previous slide? So as we talked about, the beauty of the dynasty trust is that it avoids taxation forever, and there's never a forced distribution. This is an extraordinarily important planning tool for families because over generations, not only do they not want the taxation, so that's part of it, and that drives part of it. What they really want to be able to do is control this thing and control their legacy forever. And we hear the comment, well, we want to control from the grave and so on and so forth. But, first and second generation wealth creators, they want to make sure this money's around forever. And if there's a forced distribution at some time certain down the road, then they've lost all their control. Money's outright distributed to the family, and that creates a really serious problem. Can create a serious problem because when we're talking about people with hundreds of millions of dollars of net worth, the last thing they want to have happen is that money to be distributed outright to a generation. Because as we all know, and what's been driven, what has driven these changes is if you look at families like the Kennedys and the Rockefellers and some of these extremely wealthy families in the country, statistically, there's no question that by the time third generation gets to the money, and usually before this rule, usually it's outright distribution. It destroys that generation, meaning they can't handle the money. Incidences of drug and alcohol abuse are outrageous, and money is squandered. And they call there's a book written from I guess shirt sleeve to shirt sleeve, which chronicles how this families could have worth $1 billion, and then 3 generations later it's gone. And it's sad to see that. I think this dynasty trust piece allows that to live forever, and I'm organizing it in the context of trust taxation. So when we take a dynasty trust concept and then we couple it with what we're going to talk about next about taxation of trusts, you really begin to see, Tyler, a tremendous planning opportunity. And what I had said earlier, which was the reference to the chart, these dynasty trust states are not created equally, and that's why it's really, really important to stay on top of the changes. And before we move on to the meat of the presentation, it's fascinating to watch how quickly the states are moving in this regard. Trusts, it's big business to attract trust companies to their state, and states like South Dakota and Nevada particularly have been extremely aggressive in sort of fighting it out year over year. And Alaska too, where they see something that South Dakota did or Nevada has changed, and the next year South Dakota changes it, and each year they're trying to move faster and faster to being the best trust jurisdiction. And I would argue, frankly, I think that maybe the top 2 trust jurisdictions now are probably Nevada and South Dakota. They're very similar. Their asset protection statutes are very, very similar. Probably the main difference is that Nevada allows for the there's an exemption for spouses and child support. So that's to say you can protect your assets from having to be distributed to pay your spouse and child during a divorce. I don't see South Dakota changing their law anytime soon to do that, and frankly, I'm not sure I would want to work with a client that has that as a goal anyway. But that's really the main distinction. But I'm setting the stage for the next piece of this conversation, which really gets into the heart of taxation. So trust taxation. For years, this concept of income tax obviously has been around forever, and there's been a handful of states, as the chart pointed out, that do not have a state income tax at all. So it's South Dakota, Nevada, Alaska, and a couple of other states, and I'm going to show you a chart in a moment that kind of chronicles all the states and where they fall in this. This idea of taxing a trust, though, and most of these trusts are irrevocable trusts or grantor or non-grantor trusts, they're taxed as a separate entity, which means they're their own EIN, their own person legally, so to speak, and they're subjected to taxation. And of course, we all understand that what's distributed out of a trust is is always going to be taxable, Tyler. So if you have a trust and you get $10 from the trust or $1 million, that's taxable at ordinary income. So I'm not talking about that taxation. Taxation I'm talking about is the trust or the taxation that's levied on retained income that stays inside the trust. And what a lot of folks don't realize is that not all states tax these trusts. And to select or think about putting your trust in a jurisdiction that does not tax trust can have some very compelling tax consequences. So when you couple this with the dynasty trust provisions, which means that the trust can live forever, we can create a scenario, Tyler, where a trust can live forever, literally, and never pay state income tax on undistributed income. And these lot of trusts, particularly at the current generation, don't distribute. Those trusts are to live in perpetuity or forever for the benefit of future generations. So if you have a $50 million trust sitting in a jurisdiction that doesn't tax at the trust level, and it sits there for 200 years, that adds up to a tremendous amount of money. And what I say in the last bullet point there is it's an untapped planning opportunity in our view, by virtue of just a lot of practitioners not realizing it or thinking the home state is going to end up taxing it anyway. And this is where it becomes really exciting, Tyler. is that there is, and we'll get to it in a second, but increasingly there's support that is saying that can't happen anymore. So, as we say, it's a untapped opportunity by simply combining the dynasty trust component in a jurisdiction that does not tax trusts at the state level is extraordinarily powerful and something that we've become pretty passionate about here at Bridgeford. So, yeah, this is going to be hard to see. I apologize, everybody, but this is another chart put together by Steve Oceans. What this does is it talks about, it doesn't really rank the states. It just lists all the states in the United States and their states and their tax rates. Okay, and I think it's important just to focus on a couple of the states. We do a lot of work with California residents, and as you all know, the tax bracket there, or tax brackets there, are pretty out of control, and there's a lot of movement right now to figure out how to avoid taxation, and a lot of people are actually leaving California. Well, there's a way to avoid at least the taxation on the trust, on undistributed income on the trust, and that's where I think we're seeing the most activity, because there's such a big reason to get these trusts out of out of California into a jurisdiction like South Dakota. But you look at Pennsylvania, it's less onerous. It's 3%, a little over 3%. New York, it's 8.82. Of course, New York's a whole different animal. We'll get to that in a moment. But the point is, I want to sort of underscore the importance of this. If we can figure out a way to avoid this type of taxation on undistributed income inside of a trust, and we can do so by simply just finding the correct trust jurisdiction to place the trust, Tyler, I mean, you would agree that has tremendous consequences across generations and protects these assets. I don't mean asset protection from creditors. I mean it protects these assets from taxation, and obviously it's going to make them compound and grow and have more there for the family. So the rules are tricky, and what I want to focus on now is probably the most important aspect, I would say, of our conversation together today. We need to define a few things.
Before you continue to define those things, Dave, I and maybe this will kind of be a segue into what you're going to get into. So as you've highlighted, we're talking, potentially millions of dollars that could be, taken out of a trust per se due to taxation. So if I'm a trust owner in California, am I going to have to move to South Dakota? Am I going to have to move to Florida? Am I going to have to, root up my whole family and go to one of these states with, no income tax or better income tax just to save millions of dollars for the trust? Or, how does that play out?
That's a great point. Not at all. And that's, I think, the most exciting aspect of what we're doing here. Remember I had mentioned, and thanks for the question, it's a great question, the trust is a separate entity. It's a separate legal entity from you, which has its own life, so to speak. And that's sort of, they call that legal fiction. The law created a separate entity. So by moving the trust, we should be able to accomplish that. And I'm going to talk to you now about the specifics and what the case law says in that respect. But no, you do not have to move, and that's the beauty of it. And that's where our system of individual state rights really comes to play here. And we're going to talk about a constitutional issue, two of them, that apply to this analysis. So thank you, Tyler. But before we get there, it is a great segue, because we want to talk about, first of all, what is a resident trust? A resident trust is just what you asked about. Tyler, you can set up a trust in South Dakota or Delaware and be a resident of Pennsylvania and have beneficiaries in Pennsylvania. But if that trust is properly administered and assets are not within Pennsylvania, that trust is under the jurisdiction of South Dakota or Delaware. What's compelling about that is we know those two states don't tax the trust, as I've been talking about. So herein lies the fight that has existed. States, until very recently, have been taxing those trusts anyway. And they would say to you, Tyler, hey, look, I don't care where that trust is. You're here, and your beneficiaries are here. We're taxing that trust at the undistributed income level. Well, as you can imagine, we have some very wealthy families who didn't accept that as an answer. So what we're seeing is a tremendous, I believe, and this is more my analysis, I think, than anything. I've seen in the last 18 months a clear trend in case law across the country that I want to talk about, not only for folks to see the trend, but also to feel comfortable doing this type of planning. Because what the conclusion is that we believe at Bridgeford and a lot of the practitioners is that, in fact, states can't tax these trusts anymore. And we'll get to why. But before we get to sort of that analysis, I need to make a very, very critical distinction, because it's a distinction that we're going to talk about a little bit more detail when we look at the cases. And it involves sourced versus non-sourced undistributed income. So if we're talking about a trust, and let's say it's a $50 million trust, and inside of it is real estate and closely held business stock of a Pennsylvania entity or New Jersey entity or California entity. The case law and the analysis turns on, well, one could argue, and the taxation authorities have argued this, that's state-specific sourced income. And that, therefore, should be subjected to taxation, as opposed to non-sourced undistributed trust income. And here's where it gets exciting, in my opinion. Everybody laughs when I say that, but it really does. It gets exciting because the cases have made a distinction. Non-sourced income is considered to apply to investment management accounts. So if you have a $50 million trust and it's in a relationship, it's with a asset manager, even if they're located in Pennsylvania or California or the state you're from, that does not establish that the undistributed income is sourced in that state. So I'll be more specific. Because of the fact that an investment manager custodies assets literally all over the world, they can't specifically be attributed to income in a particular state where you are, Tyler. Does that make sense? Mm-hmm. And that's what generally has been determined by the cases, is you can't really prove that a portfolio that's generating 8-10% and that's undistributed really is happening in California or Pennsylvania, because again, those assets are custodied everywhere or nowhere or in a cloud or on a computer somewhere. They're not sitting in the investment manager's vault in Pennsylvania or California or New Jersey. So that's a very critical distinction. And frankly, most of the assets that are in play in a lot of these old trusts are investable assets. So now that we've sort of set that framework, let's go to the next slide. So here's what's exciting. It's very clear that at least 3 states that I know of right now at the appellate court level have held that it's unconstitutional for a state to tax a resident trust that's properly sitused and administered in another state. It's unconstitutional. It's saying it's a violation of the Commerce Clause because they don't have jurisdiction. Pennsylvania doesn't have jurisdiction. California doesn't have jurisdiction over the assets because it's a trust that's properly administered and sitused in a jurisdiction that does not tax. It's a violation of due process. All 3 of these cases have said this, use the same analysis, and they all came out relatively close to each other. Pennsylvania was the first case to actually, and again, this is appellate level cases. And it's funny because people hear me talk all the time. I think Pennsylvania is one of the worst states when it comes to trust jurisdiction. I hope that doesn't offend anybody, but I'm sure if you're on this call, we already know that. But this McNeil case was really groundbreaking because it definitively made distinctions that said, listen, sourced income in the United States, in Pennsylvania, that still can be taxed. So that's real estate and that's closely held stock. But these investment management accounts, as I've already described and distinguished, can't be taxed. And I'm talking about the undistributed income. And it does a very nice analysis. And so not only has this case been embraced locally, when I mean local, I mean in Pennsylvania, it's been embraced by the Department of Revenue in Pennsylvania. So they've promulgated guidelines around this case to tell practitioners when they're doing trust tax returns how to do it. And at Bridgeford, we have we rely on McKonly Asbury to do a lot of these, and we have somebody who's a great technician, Angela Ducker, who has gone through and done the analysis and pulled the regulations. And in fact, this has been embraced by the Commonwealth of Pennsylvania. It's not going to be appealed to the Supreme Court of Pennsylvania, and to me, the issue's done. And what's happening is for practitioners that understand that now, and it's taken a little while, I think, for people to embrace it at the planning level, by simply moving a trust into a jurisdiction like South Dakota or Delaware that doesn't tax trust and its investable assets, overnight you can save the trust 3% on undistributed income. Overnight. Which more than justifies any additional fee inherent in having to get a corporate trustee involved to make that happen. So the case in New Jersey, very, very similar case, very similar fact pattern, and the analysis is virtually identical. They cite the U.S. Constitution, and they talk about due process and the Commerce Clause being violated by a state to tax the trust. And the most recent one is the North Carolina case. And so there's clearly a trend here that's happening, and I feel more and more comfortable as we talk to folks around the country of making the claim. Look, you can feel confident, even in states that don't have these court cases in place, that this is the trend. This is what's happening in the country, and it raises a very interesting question for those of you. And I know we have people on the call from New York State. New York State has become very aggressive in the last 2 years, as my friends in New York know, of trying to shut down these tax. I use the word scheme, but it isn't really a scheme. It's tax planning, and trying to basically say that a lot of these different maneuvers aren't going to work, and we don't care, and New York's going to tax anyway, and that's the way it goes. Well, I am very intrigued to see what happens over the next 2 years. I have to believe that some wealthy family somewhere is going to challenge those rulings and those new rules, relatively new rules in New York, as unconstitutional. And at the appellate level and other states around the country, to have it's not totally precedential and binding in New York, of course, because every state's different, but there is this trend that can't be ignored, and I think it's just a matter of time before New York is going to be overturned on some of that stuff. A lot of people watch California, and they're wondering if California is going to go the same way as New York has, and being very aggressive and sort of shutting down some of this stuff and basically saying we don't care, we're going to tax anyway. But they haven't yet. They've had plenty of opportunity to do so. They know that trusts are leaving California, which is a problem because they have all kinds of revenue crises right now. But I believe that California is aware of the trend and saying, okay, we could try to change our rulings or our approach rather at the trust tax level, but ultimately there's a very powerful constitutional argument here. And so for the lawyers and the accountants on the call, or anybody on the call, it's this very intriguing sort of intellectually, but more practically, it opens the door for a very, very, very important and easy to do planning move to save significant taxation. So as we're talking about and have been talking about, there's really a compelling opportunity here to combine the dynasty trusts, tax avoidance. Avoidance is probably the wrong word. Tax mitigation relative to estate taxation for the life of the trust. Federal taxation for the life of the trust, and then to combine that with the states that don't tax trusts at all. It's pretty compelling, and I keep using that word on purpose because it's hard to ignore this. It's hard to now know this as a practitioner and not look to an alternative trust jurisdiction, as we've been talking about. I don't know how a practitioner who now sees that this is an opportunity and understands the case law doesn't look outside of Pennsylvania or New York State or California or any other state that taxes. And the opportunity to create these trusts in these trusts in these states, or even more important, to move trusts, which is something we're going to talk about how to do that in a minute, just presents a very substantial opportunity to impact the value of trust assets over generations.
Dave, we've talked a lot today about, obviously all these different aspects as they relate to trusts and taxation of trusts. And we've really kind of focused on the United States and the different states here. And you've recently spent time in Europe. We have some international callers on the presentation today. So I know I'm curious, and I'm sure some of our listeners are curious. Are you seeing an interest from the international community to bringing or settling trusts here in the United States?
Absolutely, and our friends from the international community, I met with many of them, and in fact, I learned this from many of them. We have some folks, I think, from London on the call who enlightened me. Absolutely, for two reasons. One, there's more and more connection to the United States that next generation is having. People want to be in the United States. So you have families in Asia, you have families around the world who have their sons or daughters come here for school, and then they become U.S. citizens. And then there's really no reason at all for their trust to be Situs outside the United States. So they have looked very hard themselves across the world at these trust jurisdiction options. And as I said earlier, often the practitioners in London, and we spent a lot of time in Switzerland as well, they already know that South Dakota and Delaware are where to be. And they're moving, and that's where they're putting these trusts. I can tell you anecdotally, I was stunned to be in Geneva, meeting with a Geneva trust company, and they already were getting ready to establish trust powers in South Dakota because they knew that that's where their clients should be when they come to the United States. So it was very enlightening, and so that's the one reason. There's already a nexus, so to speak, from the family members. And then you have what is developing, I think, a developing crisis, or maybe it's been around for a while. I just became more aware of it when we were overseas. Is countries like China and a lot of other Asian countries and some Latin American countries, extremely wealthy people have a real concern that the government's going to seize their assets. And it's not just a punchline at a cocktail party. I mean, it's particularly in China, there's some real concern that the government one day is going to say, we'll seize your bank accounts. And so that is driving a lot of cross-border activity into the United States, all over the country, into the Isle of Man, into these different trust jurisdictions. And I think... again, I learned so much over there, and those two factors are driving a lot of trust into the United States. And then the other aspect of it is the United States has become a tax haven, which is pretty crazy to hear. I think he's on the call, John Nonemaker. He's a very experienced CPA in the New York City area. Forwarded me an article in Trust Advisor magazine that just came out November 5th that ranks the U.S. as the third top tax haven in the world. I mean, I didn't see that coming, and I think I'm really glad that John sent that to me. So I think that's a third reason. These international families who have interests all over the world are doing a careful analysis of what's happening across the world, and they say, hey, well, not only is USA where my kids want to be, but it's a pretty good tax haven too. So they're not only moving trust, but they're moving business interests here, and the world is really quickly changing in that respect. So we talked a little bit about setting up the trusts in these jurisdictions, but how to move these trusts. And that's where the real opportunity exists, because there are so many irrevocable trusts that exist all over the country, all over the world, that would benefit, Tyler, as I said, overnight by a move. And hope everybody on the call gets the sort of the conclusion here that it's actually much easier than most people realize to move these trusts. A lot of states have actually specific provisions that make it very easy to move trust situs. Pennsylvania's is very easy. You just have to sign off with the beneficiaries, and you can move the trust. We've used that several times. The trust protector, who we talked about that concept earlier, trust protector has that power, has the supreme power. So Tyler, if you appoint a trust protector in your trust, and we all agree that South Dakota or Delaware is where they should be, it's a stroke of a pen, and it's moved. Jurisdiction's moved. You don't have to go to court. Nobody can challenge it. It just happens. Engaging the decanting statute, and I wanted to spend a little time on that, but the final move is to petition the court, which is another way of making it happen. But I can tell you, we've never had to do that. We've never had to petition a state court to agree to moving a trust for no reason. I mean, that's not the state of the law at this point, and it's much easier to do it. Now, decanting, which is something we want to focus on the next slide, is for a lot of people a new concept. It's a little bit controversial, but it allows us to essentially create a new trust. Kind of like pouring a glass of a bottle of wine into a decanter. It's that same concept. You pour assets of an existing trust into a new trust with obviously presumably more desirable and flexible provisions. And one of the biggest aspects of decanting is the ability to move jurisdiction. So simply what you do is appoint a South Dakota trust company like Bridgeford, and then once jurisdiction vests in South Dakota because of that appointment, we use South Dakota's decanting statute, and we change the trust, and jurisdiction vests. And guess what? Taxation stops immediately. in most cases. So it's another powerful planning tool. I thought it made some sense to mention it in this context of just how easy it is to move these trusts to a more progressive trust jurisdiction. We are excited about it. We do it in some cases every day of the week as we're moving trusts in. And it's something that I think is still a relatively new concept. Not every state has a decanting statute. New York, I believe, was the first to have one. South Dakota is considered the best right now. And Tyler, if we go to the next slide, it outlines that. Again, this is Steve Oceans, the attorney we talked about before. He analyzes these states that have decanting statutes and is pretty clear that South Dakota's is the most flexible and the most robust. There's 22 or 26 states that now have these decanting statutes. But again, just because a state has a decanting statute doesn't mean that it's the best trust jurisdiction or the best statute. So the analysis has to go to the next level and say, okay, I need a decanting state. I need a dynasty trust state. I need an asset protection trust. And then you have to ask the next question, okay, so which is the best of those options? And this chart, again, does a great job of looking at that piece of it. The insurance premium tax is something I'll hit on very quickly because it's very myopic, but in the context of taxation of trusts, it can't be ignored. And frankly, I'll admit, Tyler, it was something I was not really aware of when I practiced law and even when we were getting ready to launch Bridgeford. In many circumstances, large insurance policies are taxed this thing called an insurance premium tax, and it's taxed state by state, and it's basically a way for states to take tax away from or tax an insurance company doing business in their state. It's myopic, and in fact, a lot of folks don't even know it exists, even insurance professionals. And not only for those of us who know it exists, we don't even know how it's levied. Meaning, we know somebody's paying that tax. We presume it's being taxed. We presume it's being passed along to the insured or the person paying the tax premium. But it's often hard to find because, as we all know, there's a lot of fine print in those insurance contracts. So, but we know it exists, and we know that in all states it's between 150 and 250 basis points. That's a lot. And South Dakota, as you can see, is the lowest by far in the nation at 8 basis points. That's a big savings. That's a big deal. And while myopic and not applicable in a lot of the situations, it's something that I am excited about because the practitioner needs to see that, particularly the insurance professional, by simply creating a South Dakota trust and having that trust buy the insurance policy, you can save a lot of money. Now, the question is to whom? Who gets the savings? And I have seen illustrations where it is passed to the client. I've seen illustrations where it isn't. Regardless, why should anybody have paid more tax than they should, whether it's the insurance company or whether it's the ultimate customer? It's still, when we're talking about taxation of trust, in the aggregate, this is an important aspect of it. And again, there are potential significant savings just by simply having a South Dakota trust purchase it. So as we wind down and maybe get to a point where we can take some questions, I began our conversation today by saying how passionate we are at Bridgeford and how passionate practitioners have become around the country and the world of looking at correct and proper trust jurisdiction. It really does matter today. It didn't matter 20 years ago, but it really matters. And the simple example and the focus of today's conversation on taxation is it isn't just an esoteric issue now. We can measure the damages that exist by choosing an incorrect trust jurisdiction, unequivocally. And so having said that, this decision is paramount. And as we began, I think is as important as it is to start a trust in the first place. And that's a quote from somebody from Neuberger Berman 10, 15 years ago, which I think was pretty cutting edge at that point. This chart is a compilation, compiles and combines the research of a lot of people. Steve Oceans is cited on here. Trust and Estates Magazine is cited on here. This is an objective piece that Bridgeford put together because we were so intrigued by this relative comparison, particularly between Delaware. In the United States, especially on the East Coast, there's a bias a little bit in favor of Delaware. I think most people think when they think asset protection or they think trust plan, they think Delaware is the best trust jurisdiction. when in fact, Delaware is a great trust jurisdiction, but I would argue not the best trust jurisdiction. And that's based on the opinion of a lot of people smarter than myself, and a lot of research and a lot of detailed analysis. And if we go through this chart, there's a couple of things that are compelling. We talked about asset protection, and while both states have asset protection, the look-back period is drastically different, and frankly has driven a lot of activity to Delaware. Both states don't tax the trusts. There's no state taxation, but the privacy provisions are drastically different, and I think really have to be compared when we're looking at these distinctions. They both have dynasty trust capability, which means these trusts live forever, and that's great. But if you look at the charts, when you look at all the dynasty trust states in the country, it's been compared, and as they're compared to one another, South Dakota, as I mentioned, is considered number 1. Delaware is considered number 6. So, I mean, it's not even considered top tier when you compare it to other dynasty trust jurisdictions. They both have different dynasty trust capabilities, and in many other ways they look the same. The insurance premium tax is vastly different, and they also don't have something called a special purpose entity, which is a way to shield liability for trust protectors. The point here is not at all to be disparaging to Delaware. The point is to say that if we were going to be objective in our planning process across the country, we need to look at the objective details and the analysis, and avoid hyperbole and avoid self-interested statements to say, look, what is the best jurisdiction? And definitively, we can determine that based on, again, some great research and just the facts. And so that's why we're passionate about it. And I think that every discussion we have and every presentation we're involved in, we really want to force the issue of looking at this trust jurisdiction issue. Today's focus was more on taxation. I'm happy to take questions about other aspects in the slides that people want to talk about. But I think this taxation issue is only going to become more and more interesting as more and more cases follow, or states rather, follow the trend in the case law.
Well, Dave, thank you so much for leading today's webinar. We have a few announcements before we get into some of the questions that have been asked. So as a reminder, if you are listening to today's presentation and you have any questions, please feel free to use the built-in questions function in the webinar software to send us some of your questions. But we do want to thank everyone again for attending today's webinar, which has been brought to you by McKonly Asbury and Bridgeford Trust Company. As a reminder, you will be receiving CPE credit for attending this 1-hour webinar. CPE certifications will be sent out via email within the next 15 days. And you'll also be receiving a link to a short survey about today's presentation, and we would really appreciate your feedback. So if you could do that, that would be extremely helpful to us. We will also be posting a copy of today's presentation on both McKonly and Asbury's website as well as Bridgeford Trust website. So if you're looking for a recap or want to catch the presentation again, check out either one of those websites in the next couple days. We encourage you to join us for our next webinar, which is going to be on December 17th, and it's titled Year-End Accounting Standards Update. This webinar will be hosted by McKonly and Asbury partner Janice Snyder, and it will examine the recent activity of the Financial Accounting Standards Board, known as the FASB, and the changes that they have made over the past year. We would be happy to have you join us for this free webinar on December 17th. So again, we do encourage you to submit any questions that you have. You can also you can see Dave's email address up there, so if you have any other questions after the webinar, we definitely encourage you to let him know. So Dave, I don't know if you just want to jump into any of the questions first or how you want to do this. We'll let you tackle the first one. All right, so the first question we have relates to federal taxation of dynasty trusts. We're just looking for a little bit more information about that and curious about when the trust itself is taxed, but also when are the beneficiaries taxed. And again, this is relating to federal taxation of dynasty trusts.
Thanks, Jay, for that question. And it's a good question. That's sort of the beauty of this tax planning relative to the federal taxation piece of dynasty trusts. The trust assets themselves are never subjected to federal income tax until and when they're distributed to the beneficiaries. So the idea of being able to keep these trusts encapsulated in a dynasty trust, and there's never the forced distribution, means that they will not theoretically, they will in reality never be subjected to federal taxation. The second part of the question, when is the trust taxed? I guess that's really part of the first part. I would argue never, as long as it's not disrupted. And then when are the beneficiaries taxed? And they're taxed, of course, when distributions are made to them. So even though these are dynasty trusts and they can live forever, each time, say, Tyler receives a distribution out of his trust, we are that he's subjected to his ordinary tax rates, whatever that would be, and that presents another tax planning opportunity, because if we know that in a state that doesn't tax trusts, if it doesn't tax undistributed income, there might be a tax play here not to distribute the income for a couple of years to Tyler if he doesn't need it, because all it's going to do is subject it to federal and state income tax relative to his ordinary income. And again, that's a decision that we need to make collectively as an advisor team with attorneys and accountants.
All right. Thank you so much for answering that question, Dave. Again, if you guys have any other questions or want to contact Dave at any point about taxation of trusts or trust jurisdiction, asset protection, modern trust laws, any of the above, or anything that we've discussed in today's webinar, you can see his email is there, and we encourage you to let him know. Also, feel free to visit Bridgeford's website, which is bridgefordtrust.com. A lot of helpful articles and more information about South Dakota and the benefits of working with Bridgeford Trust. So, Dave, thank you again for joining us today. You have any last words for any listeners still out there?
Not at all. Please feel free to contact us with any questions. As I hope was evident, we're passionate about these discussions and are happy to help in any way we can.
Alrighty. Thank you guys for
once
listening
again
and
for
have a great
joining
day.
us for this presentation produced by McKonly Asbury. We hope you join us and participate in our upcoming events. You can stay up to date with news and learn about our upcoming events by visiting us at www.macpas.com. Thanks again and have a great day.